NetCredit is here to say yes to a personal loan or line of credit when other lenders say no. Apply in minutes and get a decision as soon as the same day. Loans offered by NetCredit or lending partner banks and serviced by NetCredit. Application subject to review and approval. Learn more at netcredit.com/partner. NetCredit. Credit to the people.
The new developments in the Karen Read murder trial.
This has been a wild turn of events.
I've seen a lot of things. I've never seen anything like this. This case never ceases to amaze me.
It's a spectacle, that's for sure.
It was a hung jury, so no verdict, no real ending to this case.
Karen Read was back in court where a date was set for her to be tried once again.
There are a lot of issues in this case.
Proctor was improperly searching Karen Read's cell phone for nude photos.
Michael Proctor, the lead investigator,
relieved of his duties.
It's always the theories that each side will put forth for a jury to decide which one is more believable.
Karen Read was drunk and angry and hit and killed John O'Keefe when she gunned it in the snowstorm.
Karen, did you ever say, I hit him, I hit him?
I did not.
There are more people here at the beginning of this than at the beginning of Johnny Depp's trial.
We're not concerned about any of the witnesses. None of the Commonwealth's witnesses are concerning us.
And once again, there was drama outside court.
There is a whole new set of legal troubles for Karen Read. She is now facing a wrongful death lawsuit.
The lawsuit alleges that Karen Read was drunk and reckless when she hit John O'Keefe.
It's not just Read being sued here. The family also suing the two Canton bars from that night.
The two bars are liable for over-serving her.
The FBI is investigating an investigation of a murder. That never, ever happens.
At this point, multiple jurors have been reaching out to both sides, saying that they are certain Karen Read is not a killer.
I did not kill John O'Keefe. I've never harmed a hair on John O'Keefe's head.
We're looking at arm injuries with scratches. We're not looking at tire tracks.
There are 17 jurors, and they are coming and going with a police escort.
The investigation wasn't thorough.
This can't be good for the prosecution moving forward.
I just hope justice is served for either one, whatever it is, you know.
The fate of her life is not in her hands anymore. It's not in the hands of her attorneys. It's not in the hands of the prosecutor. It's in the hands of the jury now.
The high-profile second trial of Karen Read has come to a dramatic end. What started as a tragic local news story eventually drew national and worldwide attention, sparking intense public debate and tearing a small community apart. The case became a lightning rod for controversy, with truth proving stranger than fiction. Allegations of a cover-up, police and governmental corruption, and an FBI investigation that left us with more questions than answers. And now, after more than 3 years and 2 trials, 12 strangers have decided the fate of Karen Read. The jury deliberated for around 11 hours before we got our first glimpse into what they may be thinking. On Tuesday, there were 3 yellow note cards sent from the jury with questions read in court. The first was about the time of the OUI. The jury wanted to know if the OUI was for 12:45 or 5 a.m. The retrograde extrapolation that was done to guess at Karen's intoxication level specified 12:45 a.m., although we know that based on digital data, she was not actually driving at 12:45. She was already back at John's house by then. As for the 5 a.m. question, since Karen's blood was taken in the morning, the estimate on her alcohol levels would be more accurate at that time, and an OUI would likely be more reasonable. Hank Brennan wanted to answer the question by specifying that the time was 12:45, but since there's no time in the indictment, the judge said she felt uncomfortable with that, and the defense agreed with the judge. The answer for the jury was simply that they have all the evidence and they are the fact finders. The second note card was about the interviews of Karen. It read, "Are the video clips of Karen's interviews evidence? How can we consider them?" Now, the answer here is yes, they are evidence, and were entered as evidence. Jackson requested that the judge tell the jurors that they can give them whatever weight, if any, they choose, and Judge Canoni agrees. But then Hank Brennan has an issue with that. He doesn't want the judge to include if any, so she takes that part out, and although Jackson objects, his objection is noted, and in the end, the jury is told to weigh it as you would any other piece of evidence. The final note card sent at this time was about the lesser included charges on the second count. This part was confusing for a lot of people on the verdict slip. Here's the problem. There are 3 counts or offenses as they are listed on the verdict slip. The first is the second-degree murder, and that one is simple, guilty or not guilty. The third is leaving the scene of an accident causing death, and again, that one's simple, guilty or not. It's the second offense, manslaughter while operating a vehicle under the influence, that is the confusing one. I went over this in detail in the last episode, but the way that this offense is set up, it has this as the main count, but there are lesser included charges with smaller penalties underneath. So if the jury doesn't find her guilty of that charge, they could potentially find her guilty of the next one under that, which is involuntary manslaughter. If they also agree not guilty to that one, then they move on and look at motor vehicle homicide, felony OUI, and negligence. And if they agree not guilty on that one as well, they move on to the final one under count 2, the OUI, which is basically just driving drunk. Now, Yannetti proposed a new verdict slip on Monday that he said made things simpler for the jury, giving the option of guilty or not guilty for each of the lesser included charges, since the slip is so convoluted and hard to understand. But Judge Canton denied it without a hearing. Ironically, now the jury is confused by the slip and about guilty and not guilty on each. Their question is, does convicting guilty on a subcharge convict the overall charge? The example they gave was offense to number 5, which was the OUI. So they're wanting clarification to know whether or not, if they convict on the OUI, that means that she's also being convicted of the manslaughter while operating a vehicle under the influence charge. The judge didn't adopt the defense's proposed clearer verdict form here, but she did alter the verdict form some to try to help make it clearer. A little more than an hour later, another question from the jury, which we find out actually came before the other 3.
If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge?
If they have found her not guilty on 2 charges and hung on the other. The other would be the OUI under the manslaughter based on the questions that they asked, and the not guilty would be on murder and leaving the scene, same as the other jury. When I heard this, I felt a wave of relief rush over me. They saw the evidence for what it was. They didn't let the theatrics fool them. They paid attention. They're going to find her not guilty of murder. And if they are only asking about the OUI, that means that they've all unanimously agreed that she's also not guilty of the manslaughter offenses. The only thing that it seems they're hung up on is the OUI. And they're concerned that if they can't agree on that, it will be a hung jury on all offenses. But that relief left just as quickly as it came when I heard the discussions over what to tell the jury. The judge says she didn't want to answer this because it's hypothetical, and she wants to just say this is not a question she can answer. Jackson vehemently objects to that, telling Judge Canton, you can answer that. And if you don't give some kind of clarification, we're going to end up right back here for the 3rd time. If the jury thinks that they have to be unanimous on all charges before giving an answer, then they won't give their 2 not guilty verdicts. That's exactly what happened in the last trial. And now it looks like this could potentially be happening again right before our eyes. Jackson makes very clear that he wants some kind of answer or clarification given to the jurors. At least just tell them it's premature to address this, so that if they do have those 2 not guilty verdicts and are hung on the other, they can tell the court that and at least get those on the record. Again, the judge notes Jackson's objections, but also basically ignores them. The answer is sent back to the jury, and again, we wait. 2.5 hours later, the jurors go home for the day. I mentioned in the last episode that I truly believed the only just verdicts would be not guilty for the offenses charged, but if there's any guilty verdict, I believed it wouldn't be for the offenses charged, but for the lesser included of the OUI. And I believe that it would be in large part based on Karen's own video clip where she admitted to being buzzed. And based on the jurors' questions, that's exactly what happened. But if they can't come to an agreement on the OUI charge, the way that the verdict slip is written means that they would hang on the manslaughter charge, even though they all unanimously agreed that she wasn't guilty of that. It doesn't seem logical or fair, but it's Massachusetts law. On Wednesday, day 36 of trial, jurors return to the courthouse and begin deliberations again. Every hour that passes makes me more nervous about another hung jury. Around 2 o'clock that afternoon, there's finally some kind of word from the jury. We hear that they knocked on the door and had a verdict. They gave a verdict form, but then shortly after, knocked on the door again and said it wasn't their verdict. The sealed envelope was brought in and marked for identification, but remained unopened. Soon after that, we get word that now it's official. There is a verdict. The jury has reached a unanimous verdict on all 3 counts. Attorneys and family make their way back to the courtroom, and the jurors are brought in. The verdicts are read. First up, offense 1, second-degree murder.
Murder in the second degree. What say you? Is the defendant at the bar guilty or not guilty?
Not guilty.
Not guilty of second-degree murder, which carries a mandatory life sentence with opportunity, but not guarantee, for parole after 15 years. Karen Reed is not guilty. Next is the second offense, manslaughter. This is the one that the jury was confused on because of the form that the judge refused to change. There was even confusion when the verdict was read out loud.
002. What say you? Is the defendant at the bar not guilty or guilty?
Not guilty.
Of.
Is not guilty or guilty of that charge or any lesser included charge?
Lesser included.
Thank you. Specifically, number 5, operating under the influence of liquor by operating a motor vehicle with a blood alcohol level of 0.08 or greater. Correct?
Yes.
So say you, Mr. Foreman?
Guilty.
So say you all?
Yes.
The foreman said not guilty to the manslaughter charge, which is the other severe charge that carries the largest sentence. But they did find Karen guilty for the OUI, driving while under the influence. And finally, the third offense.
003. What say you? Is the defendant at the bar leaving the scene after accident resulting in death? Is the defendant not guilty or guilty?
Not guilty.
So say you, Mr. Foreman? So say you all?
Not guilty. Karen Reed has officially been acquitted of murder, manslaughter, and leaving the scene of an accident causing death. You can hear the screams and cheers outside as people get word that Karen Reed has been acquitted. She has been convicted of a misdemeanor of driving while intoxicated. She was found not guilty of every single offense that involved any kind of collision with John O'Keefe. And the only one that she was found guilty of is the one that didn't involve a collision. One that she admitted to on camera, driving while buzzed. Right after the verdict is read, the judge thanks the jurors and tells them that their service is complete. The family and friends of John O'Keefe file out of the courtroom before the judge finishes speaking to the jury. Moments later, the jurors are taken out, one in tears, as Karen Reed hugs her attorneys. David Yannetti, the attorney who has been with Karen Reed since day one, is visibly emotional, wiping tears from his eyes as he exhales. A world of worry and weight on his shoulders finally lifted. Karen's parents are also emotional, wiping tears away as they embrace each other, trying to stay calm until they can get outside of the courtroom. Karen is sentenced to the standard for a first-time OUI offense.
Hey, Mr. Brennan, what's the Commonwealth's recommendation?
Your Honor, the Commonwealth moves for sentencing. We recommend probation, 1 year, 24D program.
So the standard that everybody else gets on their first-time OUI?
Certainly.
Okay.
We ask that she be treated no differently, no better.
So I'm happy to do it. All right. Thank you all.
1 year of probation and a 24D program, which requires a certified driver alcohol education program and 32 hours of group therapy. After the sentence is read, Karen turns to her family and hugs them for the first time since finding out that she's free and she's going home. She takes time to hug each of her attorneys and the interns and her family and her friends, while outside, the crowds continue to cheer and celebrate as helicopters swarm and news crews set up. After a while, Karen, her attorneys and her family exit the courthouse, smiling and giving the I love you sign with their hands, which has become a symbol for Karen and her supporters. They approach the microphones that are set up on the courthouse steps, and Karen addresses the crowd for the first time.
I just want to say two things. Number one is I could not be standing here without these amazing supporters who have supported me and my team financially and, more importantly, emotionally for almost 4 years. And the second thing I want to say is no one has fought harder for justice for John O'Keefe than I have and my team. Thank you.
As attention grew around this case, so did the number of Karen's supporters. Some of these supporters spent months or years protesting the charges against Karen. They would show up to fundraisers, court hearings, standouts, and even highway overpasses, dressed in pink with signs that declared her innocence, while demanding justice for John O'Keefe and Karen Reed. As Karen made her way through the chaos, pink confetti pops over the crowd, while many of these same supporters continue to cheer, while others embrace each other and cry. An emotional ending to a long fight for a cause that they truly believed in. We'll be right back after this.
NetCredit is here to say yes to a personal loan or line of credit when other lenders say no. Apply in minutes and get a decision as soon as the same day. If approved, applications are typically funded the next business day or sooner. Loans offered by NetCredit or lending partner banks and serviced by NetCredit. Application subject to review and approval. Learn more at netcredit.com/partner. NetCredit. Credit to the people.
You know who's surprisingly good with money? Greenlight Kids. The other day, mine stopped to think about the ROI on a bag of chips. Seriously. From getting paid for doing chores around the house to saving up for concerts, Greenlight's teaching my kids how to handle their money.
Greenlight your kids' financial future with the #1 family finance and safety app. Try Greenlight risk-free at greenlight.com/podcast.
The dust had barely settled when interviews began popping up all over various media outlets. For the first time, we heard from some of Karen's attorneys, including Jackson, Yannetti, Alessi, and Victoria George, the former alternate juror turned attorney who joined Karen's team this year. The Alberts and McCabe's also did an interview, and former Trooper Proctor spoke out on national TV, giving his side of things. And, most importantly, we heard from some jurors who gave us some insight into what they were thinking and how they weighed the evidence. Let's start with Proctor. Proctor did his first interviews since he was terminated from his position. And surprisingly, he says that when it comes to the investigation, there are maybe a few witnesses that they could have interviewed sooner, but he says overall, he wouldn't change anything. That's kind of crazy given what we know. He also said he never even considered recusing himself, claiming that there were only quote-unquote loose connections between him and the Albert family. Again, kind of interesting given we know that members of his family called the Alberts their second family. He calls his texts regrettable, but says that when he texted that he hopes that Karen kills herself, that was just a figure of speech. He said that he was just caught up in the moment of investigating, saying things based on feelings that had developed against Karen as the case went on. Proctor's wife interviewed with Dateline and said that it was uncomfortable listening to those texts on the stand, and she admits that there's no excuse for them, but she said she wasn't deeply offended by his words, and she called them juvenile. In that same episode, Proctor said he was venting in those texts, using words that he regrets, but that's not who he is as a person. Now, when talking about being relieved of duty, Proctor got emotional, saying that the hardest part of it was having to turn over his Class A uniform, something that he had been so proud of after 6 months at the academy. I'll say this. I have a huge problem with what Proctor did. It was unprofessional and gross what he said about Karen Reed. And sharing information about an investigation goes against the expectations of his position. He has now been given consequences for those behaviors. So I do hope that from here, he's able to move forward a better person after having learned these lessons the hard way. Although he does say he's appealing those consequences. So I guess we'll see. Another ABC interview that had people talking was the Nightline interview with Brian Albert, Nicole Albert, Chris Albert, and Jen and Matt McCabe. They were discussing the trial, the outcome, and the allegations of their involvement. Brian Albert says the criminal justice system has let them down.
The criminal justice system has let us down at every turn. And yesterday was the final letdown. And that's why we're here, because there's nobody left to stand up for us.
Brian Albert says the reason he didn't go outside that morning is because he wasn't part of Canton PD, he was Boston PD. And he says by the time he came downstairs, John was already gone, so there was nobody left to save. He also says he doesn't understand how people bought the defense's theory, claiming that this conspiracy would have to involve 30 to 50 people, including multiple civilians, EMTs, and the medical examiner. Of course, we know that that's not accurate. Another claim that was discussed that wasn't accurate, they said that the defense could have gone to get DNA from Chloe at any time to compare the DNA taken from John's injuries. But we know that there were no swabs done of John's injuries. They also say that they've been called murderers since this happened.
What they've done is they've dehumanized us to the sense where we're not real people. We're almost like caricatures. We're pawns.
Have each of you been called murderers? Like actual murderers?
Oh, yeah, on a daily basis.
Anybody who's touched this case has been called a murderer at some point.
And anyone who's friends with us support cop killers.
Yeah.
They said that they just did their civic duty and told the truth. And Nicole Albert tells people that they should think twice before being witnesses in a case.
We did the civic duty, came and told the truth, and that's it.
Think real long and hard before you're a witness in a case, because no one protects you. And it's very, very sad.
The Alberts and McCabes said that their lives are forever changed, and they feel like the O'Keefes did not get the justice that they deserved. Moving on, we have also heard from the attorneys since the verdict came out. Defense attorney Alan Jackson spoke to Howie Carr, and he had a lot to say. Jackson said he never doubted Karen's innocence, but he did have doubts about getting a fair trial in Norfolk County.
I mean, I never doubted the evidence. I never doubted her innocence. I never doubted Karen's, the just result should be that Karen walks out of that courtroom in the front door, through the front door, not the back. But did I doubt whether or not I could get a fair trial? About every single minute of every single day.
Jackson also says that Judge Canoni basically had their hands tied behind their backs and made multiple bizarre rulings that benefited the Commonwealth, something that I think we all witnessed over and over.
This is still just shocking to me. There was a witness that I took on direct examination. It's direct, and it's an expert. Every question I asked was objected to by Hank Brennan, and 100% of his objections were sustained. I've never seen that in 30 years of practice. Literally, I think it was 49 objections and 49 sustained objections by Hank Brennan and the judge. Talk about trying to keep the information from the jurors. It's not like I was abusing my position trying to get information in that was not relevant. I just had to ask the question 17 different times in 5 different directions to get the information in front of the jury. I've never had a situation where the judge sustains every single objection by the prosecution. That's never happened. Statistically, it's impossible.
Jackson said it began to look like Judge Canoni had her own idea of what should be presented to the jury and how.
It certainly seemed like the Judge Canoni had an idea of what she thought should be presented to the jury and how she thought it should be presented to the jury instead of just being, calling the balls and strikes. That's what she's there for. Her job is very, very it's simple. She is a gatekeeper of the evidence, for sure, absolutely. So you don't want to allow abuses on either side to occur in your courtroom, but you allow the lawyers to try the cases. You allow the lawyers to direct examine the witnesses or cross-examine the witnesses. You allow the evidence to come in before the jury because ultimately the jury is the trier of fact, not the judge. The most important folks in the room are the jurors. So it struck me after a while, and it struck me in trial number one. She did the same thing. It was just, in my view, abusive of the process, not allowing the system to just work.
Howie Carr asked Jackson if he had to say one thing to Judge Canoni, what would it be?
My suggestion would be just do better. Don't try to put your thumb on the scale. No judge should ever try to put your thumb on the scale. Let the evidence get before the trier of fact in a fair and, above all else, an impartial way. I did not feel this was an impartial judge. I just didn't. And I don't think anybody who's watching would argue with that.
When it comes to Hank Brennan, Jackson said that when Hank first came on this case, he said he was here to make sure that Karen Reed got a fair trial. But it didn't take long to see that all of that was just lip service, because Brennan obviously did not want the jurors to actually hear the evidence.
Hank Brennan came on as this, sort of self-proclaimed stalwart of justice. We're going to make sure that Karen Reed gets a fair trial. That was just lip service. It was anything but that. The Commonwealth had a theme and a theory going into this case that they did not want the jurors, in my view, they did not want the jurors to actually hear the evidence. They had no interest in having the jurors presented with the truth and the evidence on both sides, even playing field. Everything they did strategically was to try to hide evidence, try to hide witnesses, try to hide experts from the jurors. They filed motion after motion after motion.
And that goes for Michael Morrissey, too, the Norfolk County District Attorney. Alan Jackson says the same thing that I've been saying for years. Their job is to seek justice, not win a case. And Jackson says that the way that they prosecuted this case was an abuse of power. They continuously filed motions to try to keep the defense witnesses away from the jurors. Overall, Jackson said he's pleased with the outcome, and he believes the right thing happened despite the effort of the judge and the prosecutors to tip the scales. Jackson summed it up with one main thought.
This is the most challenging case I've ever tried in my life. And we didn't win because of the process. We won despite the process that was put in place in that Dedham courtroom. It was a travesty, in my view, an absolute travesty.
For the full interview, you can check out HowieCarrShow.com. Bob Alessi and David Yannetti also did a great interview with Ian Runkle from Runkle of the Bailey on YouTube. It was incredibly interesting to hear some of their perspectives, including the tremendous, deep respect that they have for the jurors, the court officers, and each other. One interesting moment from that interview: the morning the defense team crashed the hearing with Hank Brennan trying to get the communications between Karen and Turtle Boy. They said that they were in a conference room downstairs where they had been directed, and they decided to watch the live stream of the hearing to see what was happening. When they turned it on, they heard that it was being called as the case against Karen Reed, and they were shocked. They said they ran upstairs, told the court officer that they needed in, and then they were able to walk in, frustrating Hank and causing one of the most memorable moments in any of the pretrial hearings. That is also a great interview, and I definitely recommend checking it out. And that brings us to the juror interviews. Now, this is what I was the most interested in, because while we are able to talk about the evidence and weigh it, debate it, discuss it, they can't do that until the end. And even then, we don't know how they have perceived any of it. But some interviews that have come out since the trial have given us some insight into this. Juror 11 has done a few interviews since the verdict came out and said a few things that were really interesting to me. One is that the taillight was the main piece of evidence that determined where she saw reasonable doubt here. She said that when the car was leaving John's driveway, the taillight was lit up red, and it didn't look like that in the Sally Port. Also, when asked about the most memorable witness, she said it was Buchanan, because she said that she was seated in the first row of the jury box and said she could see him clenching his fists a few times when things got very tense. Also, she said ARCA was very big for her because they were able to make a lot of the technical information finally make sense.
The last witness, ARCA, from the defense, that made clear, they did a very good job, like showing us, explaining all the technicalities, of everything. And we couldn't prove there was a collision and she was responsible for John's death.
Oh, and she didn't know that it was the FBI who hired ARCA, but she said she assumed it after it was said that they were hired by another agency. And finally, she said that she wants people to understand that their duty was only to determine whether there was reasonable doubt. And she was emotional when she left the courtroom because she said she was sad for John's family. But she said it isn't the jury who failed the O'Keefes. It's the Commonwealth and the police who did.
It was because I was sad for the family, because I feel like great for Karen Reed, but horrible for the family. He seemed to be a very nice guy, the story with his nephews and niece, and was alive. So I feel bad for them, and I really want them to get justice for John O'Keefe for real.
Juror number 4 also did an interview and said there was reasonable doubt, which is what made them vote not guilty. There were too many holes in the case that were never able to be explained, and he doesn't know what happened, but knows that there wasn't enough evidence to convict. Juror number 12 also did an interview and said that she was actually leaning guilty when she went into deliberations, but she changed her mind as they went over the evidence. She said at one point there was a piece of evidence that she went to look for specifically, and it wasn't there. And at that time, she knew that something was up, but she wouldn't say what that piece of evidence was. And finally, the jury foreman also did an interview, telling the Boston Herald that he felt like the case wasted taxpayer money on paper-thin evidence that failed to bring any comfort to the victim's family. The foreman said if a body was on his property, his house would have been stormed. He also said he struggled with the times he would look over and see John's mom wiping away tears. But based on the lack of evidence, he knew that they couldn't lock Karen up. The overall theme of the jurors, there was reasonable doubt. And while they don't know what happened, they know that there wasn't enough evidence presented to convict Karen Reed. We'll be right back after this.
Did you know 39% of teen drivers admit to texting while driving? Even scarier, those who text are more likely to speed and run red lights. Shockingly, 94% know it's dangerous, but do it anyway. As a parent, you can't always be in the car, but you can stay connected to their safety with Greenlight Infinity's driving reports. Monitor their driving habits, see if they're using their phone, speeding, and more. These reports provide real data for meaningful conversations about safety. Plus, with weekly updates, you can track their progress over time. Help keep your teens safe. Sign up for Greenlight Infinity at greenlight.com/podcast.
We all belong outside. We're drawn to nature, whether it's the recorded sounds of the ocean we doze off to, or the succulents that adorn our homes. Nature makes all of our lives, well, better. Despite all this, we often go about our busy lives removed from it. But the outdoors is closer than we realize. With All Trails, you can discover trails nearby and explore confidently with offline maps and on-trail navigation. Download the free app today.
Unfortunately, jurors had no idea what they were getting into, and they've already been receiving online hate and threats by unhinged people who are unable to cope with a decision that they disagree with. This behavior is concerning, and it could cause future potential jurors to not want to serve on a jury. And who could blame them? Some of the same people who are preaching about harassment are actively harassing these jurors. And it begs the question, would the outcome have been different with other jurors? Based on a recent poll of Norfolk residents, probably not. Opinion Diagnostics a Massachusetts-based polling and market research firm, conducted a scientific and statistically representative poll of more than 1,100 Norfolk residents, and the results were eye-opening. 93% were familiar with the case, including 61% who followed the second trial. Only 6% of eligible jurors who were familiar with the case believed that Karen should have been found guilty of manslaughter. Only 6%. In fact, 54% who were familiar with the case believed she's completely innocent. The remainder would have voted not guilty based on lack of evidence or reasonable doubt. So, do these jurors who are sharing their thoughts and experience deserve the animosity and threats that they're receiving? No. They came to the same conclusion that it seems the majority of the population did. There's too much reasonable doubt. But, unfortunately, that hasn't stopped these online attacks. Some of the same people who have previously argued that harassment is wrong have been the exact people relentlessly harassing these jurors. They are making racist comments, calling them vile names, posting things about their family, and even wishing harm on their children. Hopefully, these sick individuals who are attacking the jurors seek professional help on how to cope with their anger. There are resources out there. Massachusetts State Police Colonel Jeffrey Noble also released a statement, first extending condolences to the O'Keefe family, and then reassuring the public that the events of the last 3 years have challenged their department to review their actions and take concrete steps to improve training, oversight, and accountability. Colonel Noble says that their focus remains on delivering excellent police services that reflect the value of professionalism and maintain public trust. As for Norfolk District Attorney Michael Marcy, his office has been contacted countless times for a statement, and he apparently won't be answering any questions. The only statement was 4 words, quote, "The jury has spoken," end quote. Meanwhile, legal proceedings aren't quite over for the O'Keefe family. The wrongful death civil suit that they have filed against Karen, C.F. McCarthy's, and Waterfall was delayed until after the criminal trial. And now that that has concluded, we can expect the civil trial to pick back up again. And of course, Aidan Carney was recently found not guilty during a bench trial for the charges brought against him that we discussed in episodes 31 through 33, but he still faces multiple counts of felony witness intimidation for the alleged intimidation or harassment of witnesses in Karen's case. Some of those have already been dismissed. Some of them are still pending. Although the end of the trial brings closure in some aspects, it doesn't bring answers. A flawed investigation, plagued by police misconduct and ever-changing theories, has left many people still wondering, will we ever know for sure what happened to Officer John O'Keefe? The evidence has been hotly debated. Why did so many witnesses change their statements? What caused those injuries? How did this happen? And could Karen really have broken her taillight when backing into John's car in the driveway that morning? Well, for this question, it seems like once again, as always with this case, truth is stranger than fiction, and we may have got an answer in the most unpredictable way. A local journalist who has been one of the most vocal about believing that Karen is guilty actually backed into another car leaving the courthouse on the day the verdict came in. He slowly backed into a truck and, you guessed it, cracked the taillight. It didn't take long for those videos to begin to circulate all over social media. So I guess it very well could have happened exactly like the defense claimed. And how ironic that that was proven by one of the defense's biggest critics. You couldn't make this up. Although the focus of a trial is the evidence and what the evidence proves, it's impossible to go through any trial without also acknowledging the victim and the legacy they leave behind. A not guilty verdict from this jury doesn't mean that the jury has failed John. In fact, juror number 11 said it best in her interview when she said, "We didn't fail the O'Keefes. The Commonwealth did. The police did." Perhaps part of John's legacy will be the changes that are made to the police force and the Commonwealth to prevent this kind of failure from ever happening again. This long-awaited verdict may have given closure to the criminal proceedings, but the controversial case of Karen Read will have a permanent impact on the people involved, and on the town of Canton, and on the way that Massachusetts State Police and Canton Police conduct investigations. And I think it will have a permanent impact on so many others as well. This case has shown the world that there are always two sides to a story, and it's important to question a prosecution because that's how justice is protected in a fair legal system. Prosecutors are representatives of the government, and they hold a lot of power. Questioning their case helps to ensure that power isn't abused. After all, trials are not about winning. They're about uncovering the truth by hearing both sides and testing the evidence. And no matter where you stand on what you think happened on January 29th, 2022, one thing is for sure. The case of Karen Read ignited important conversations about justice, ethics in government and policing, and the power of questioning official narratives. The case sparked an interest for thousands of people to become more engaged in understanding the importance of transparency in legal proceedings. And for some, it inspired a renewed passion for standing up for what they believe is right and demanding fairness. In that way, the movement to free Karen Read may lead to greater civic awareness, stronger advocacy for truth, and possibly an awakened realization about the importance of every voice being heard. After more than 3 years of fighting a system that was trying to bring her down, Karen Read is free.
My name is Brandy Churchwell, creator of 13th Juror Podcast. If you're enjoying it, please leave us a review on Apple Podcasts and Spotify, and share this episode with your friends. For more information, photos, and episode guides, visit our website at 13thjurorpodcast.com.
You know who's surprisingly good with money? Greenlight Kids. The other day, mine stopped to think about the ROI on a bag of chips. Seriously. From getting paid for doing chores around the house to saving up for concerts, Greenlight's teaching my kids how to handle their money.
Greenlight your kids' financial future with the #1 family finance and safety app. Try Greenlight risk-free at greenlight.com/podcast.
At Designer Shoe Warehouse, we believe that shoes are an important part of, well, everything.
From first steps to first dates, from all-nighters to all-time personal bests.
From building pillow forts to building a life.
For all the big and small moments that make up your whole world, DSW is there. And we've got just the shoes. Find a shoe for every you from brands you love at brag-worthy prices at your DSW store or DSW.com.